The next issue I wanted to come on to is to look at the impact of the Jackson recommendations on the third-party funding market. One of the key points seems to be that there's a potential for unlimited liability for adverse costs, and coupled with the possibility of the ATE market going seriously south if parties are no longer able to recover ATE premiums. So Neil, is that going to mean your investment's going to be drying up?
No, I don't think so. We would see the Jackson report as being very positive for third-party funding. I think the first and fundamental point is that Lord Justice Jackson gives effectively public policy approval to third-party funding if there is any lingering concern about maintenance and champity. It's quite clear now, post-Jackson, that there's support for third-party funding at a high level of the judiciary. So I think that's the first point. As far as the adverse costs are concerned, as far as that issue is concerned, we've always worked on the assumption at Therion that there was always the potential that we would be ordered to pay the whole of the adverse costs. Although the current case law says we'd be only limited to our exposure, I think you're just waiting for a case where the court decides that that doesn't apply in this instance and therefore the funder should be held liable. We've always taken that view and we've always insured the full risk and to ensure that that risk is covered. Jackson's provision and Jackson's view doesn't change that, and so it doesn't affect our model at all. And we don't think that the AT market there's any threat to that being able to continue to provide the insurance for us, certainly.
Okay. Susan, do you agree with that?
Yes, I do. I mean, I think that in the absence of much case law in relation to third-party funding, nothing beats a bit of judicial pronouncement to say, come on in, chaps, the water's lovely. We keep talking about our profession being conservative. We like some case law to take a look at, but it really does help to have somebody like Jackson writing what's actually a very benign chapter in relation to funding, but as a result, a very positive chapter, because there were still members of the profession who thought you just couldn't do funding. And to be able to say, well, do you want to take a look at Chapter 11 and see what you think after that, is really helpful for getting those naysayers really put to bed finally, and saying that funding is now very much an accepted part of the landscape. So it's only positive from our point of view. And
you don't see the AT issue as a problem?
No, not at all. The position is such that we are so conservative about how we budget for costs, i.e. we take a very bleak view of the world, that we make assumptions that we won't recover premiums, that we won't recover success fees if we're operating under a conditional fee agreement. So from a business point of view, that doesn't make any difference. We will continue to buy after the event insurance, and if we have to bear the premium, well, that's fine. It doesn't make any difference to us.
Gavin, from a practitioner point of view, do you share that optimism that third-party funding seems to be set to grow and grow?
Yes, I do. I think it will always remain, certainly in the commercial field, very much geared at the higher end of the market in terms of claims that are likely to be successful and the amounts in dispute. But yes, I think Jackson's very positive on that. It's heartening to hear from Neil and Susan that their appetite is not going to be diminished in any way by the suggested changes from Lord Justice Jackson in terms of recoverability of costs against the third party. From a litigator's perspective who acts for both claimants and defendants, that seems to me to be a sensible thing. I think it will be fairer on the parties, but it's great to hear that it won't affect third-party funding.
Kerry, I mean, one other thought out there is that contingency fees may become legal, and that means lawyers will be a direct challenge to.
Yeah, they are effectively legal if you instruct the right lawyers like me to prepare them. And we do a lot of contingency fee arrangements in this country for US law firms and US companies who don't understand why you can't do it here. And there are ways that you can do that. There's a number of interesting points here. First of all, being sweet and reasonable today because it's being filmed, but I will say the Jackson report is the most woefully written report in the history of the law. It's a truly appalling document. Unfortunately, I know virtually every word of it. And I'm afraid some of you are making some fundamental, not errors, but you failed to read the preliminary report. Personal injury cases, this is paragraph 2.6, preliminary report. There is no TPF for personal injury claims. Rule 9014, Code of Conduct, prohibits a solicitor from acting in personal injury claims in association with a funder who will receive a percentage of the damages. However, that's being looked at by the Law Society and the SRA. A number of points there. The Law Society has no power over solicitors now at all. But what Jackson did is he spoke to funders. So he spoke to me about contingency fees and employment cases, because I'm known for that. In fact, what he should have done is spoke to Susan about that and me about funding to get a different view. Because obviously, if you ask the question to the person, you predicate the answer. What no one except me seems to be, and John has, is Claims Direct was a classic third-party funder. Absolute classic. Before the success fee became recoverable from the other side, the model that Claims Direct worked on was they took a percentage of damages. That's why it became banned by the Code of Conduct. And they funded the other side's costs. So it was a form of after-event insurance. They funded medical reports, writ fees, and so on. They lent the money to the client at not especially high rates of interest. And they took a percentage of damages. Claims Direct were the biggest third-party funders in the history of this country. They were loved by the government at the time, absolutely loved, to the extent that the civil procedure rules were changed to give Claims Direct, because there was no after-the-event insurance being taken out, an extra fee for that sum. I mean, the Ministry of Justice, or whatever it was called at the time, they were so blatantly pro-Claims Direct, it was embarrassing. And I've got the notes, and I've got the memos, and I can defend the libel proceedings on it. So we've been here before. Now, having said that, I learned a lot from Claims Direct. They changed things overnight in terms of access to justice to the public, or perceived access to justice. They got greedy, they did things wrong, and they realised, to their surprise, that they could take lawyers, barristers, doctors, they could get a cut from everyone, and they did, and they got out. It seems to me absolutely inevitable that there will be a major third-party funder or a major funder who will fund personal injury work. It has the things that the funders love. It's predictable. Susan quite understandably talks about a defendant able to pay. Well, the defendant in a personal injury case is virtually always an insurance company. It actually ticks all the boxes, save for the high value. But if you put it all together, it's extremely high value. I have no objection to that. Indeed, I hope to be one of those involved in a mass personal injury market with that type of funding. But it won't be through the medium of solicitors. That's dead for personal injury. It will be an ABS or an unregulated body. And I do think that whether it needs to apply to business, I don't know. That's not my area of specialism. But in what is real consumer work, where people are vulnerable, we've seen that with Claims Direct, I am very strongly of the view that third-party funding in that field, especially with the abolition of recoverability of success fees, could be very valuable for the public, but needs clear, precise regulation.
Well, we'll come on to regulation in our next topic. John, do you agree from your research that Jackson is generally positive for third-party funding?
He seems to be generally positive, although I was kind of taken by, we now have the consultation paper following on from Jackson, and third-party funding, I think, gets 12 lines in the paper. It is one paragraph, and it doesn't really say anything about it. So, I mean, I don't think it's caught the government's imagination at all. But yeah, Jackson is generally positive about third-party funding. I wonder to what extent, although Susan talks about the idea of kind of recoverability being scrapped, not affecting her business model, but I wonder the other funders, I'm sure it's going to have a big impact on it. I was talking to one of the insurers who I quoted in the report, who was basically saying it kind of underpins the market. So I wonder to what extent that is going to make an impact. And on the point about kind of consumer claims that Kerry was talking about, I think the idea of a Claims Direct coming down the line, following on, I think it is a very interesting environment, because we have kind of what's happening in legal aid. We have October the 6th with the ABSs coming on stream, and it does seem to be there's a blindingly obvious connection to be made there, and it might have grave implications for consumers. And I was interested in Angus's research talking about, I think you mentioned obliquely a consumer model out there already. I don't know if you can tell us any more about that. You were talking about anecdotes about a consumer model in operation.
I'm trying not to name the
Yeah.
companies. That's the problem.
Caginess about it.
Yeah, I mean, yes, certainly in our research we found that there are consumer models that already exist, but they look at particular types of claims for funding. So we're seeing one, and I will be cautious here, we are seeing one that is largely based around a sort of collective action on mis-selling of pensions. Mis-selling of payment protection insurance.
Right, yes.
And so it's looking at signing up large numbers of consumers and funding the case. Now, we see that kind of model in other jurisdictions, in Europe and in the US to a lesser extent, I think. But I can see that I sort of almost entirely agree with what Kerry's saying about October the 7th. I think you will see companies like that starting to move heavily into the third-party funding market.
Malcolm, I was wondering from your angle, do you see investors being scared off by some of the implications of Jackson, or do you agree with Susan and Neil?
I don't think investors are scared off by Jackson. I think Neil's right. It's an endorsement of litigation funding. My concern with investors is, do they actually understand investment? Because I think it's a complex product, and I think that is part of the issue. It is people understanding what this product is, how it operates, where the returns come. And from an investor's point of view, it's the uncertainties. All the time that there are uncertainties, has an effect on the return they expect for that investment. And we all know that litigation is notoriously uncertain, both in terms of how long it takes, how much it costs, what the damages are going to be, how much of the potential downside for losing, etc. All these are big uncertainties. So if I'm going to take that risk, I want a big return as an investor. Otherwise, I'll go and invest in a satellite or a horse, or something else that's a risky activity. But that's the issue, I think, because funders at the end of the day have to compete for capital. And the more they have to compete for capital with uncertainty, the higher the price will be. Jackson actually removes some uncertainty, but I think he also creates some as well.